Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Rausam Pereira. Today too, we will continue our series on the Srikrishna Committee report on data protection. The draft for the Personal Data Protection Law proposes exemption of personal information from disclosure under the Right to Information Act, which can cause harm to the person concerned. The report, prepared by a 10-member committee set up last year under the chairmanship of the retired Supreme Court Judge Justice BN Srikrishna, said the data protection law is designed to limit the processing of personal data to legitimate reasons where the flow of information is beneficial and respects autonomy of the data principle. The report, which was submitted to the government last week, has proposed amendments to Section 81J of the RTI Act, which mentions exemptions from the disclosures under the Act. The report noted that nothing contained in the Data Protection Bill will apply to the disclosure under Section 81J. This is to prevent privacy from becoming a stonewalling tactic to hinder transparency. On this edition of The Big Picture, we will take a closer look at personal data and the RTI. Joining me on the program today are Anjali Bharadwaj, co-convener, National Campaign for People's Right to Information; Yashovardhan Azad, Information Commissioner; and Piyush Singh, Advocate of the Supreme Court. Thank you to all my guests for joining me on this edition of The Big Picture. Piyush, I'd like to begin with you. Let's first put into perspective and establish what can be categorized as personal data according to the draft bill.
There are two important aspects. So when the committee was considering the data protection, they considered transparency to be one aspect and privacy to be the other aspect. So they were controlling, or I would say they idealized or compared two rights, but they also idealized and compared to, I would say, constitutional fundamental rights per se. But right to privacy was taken to be maybe a hindrance in some cases with respect to right to information when it comes to data accessing. So with respect to that, 81J of the RTI Act, which states that certain kind of information which has unwarranted access to private information should not be disclosed. So that was an exemption to disclosure under 81J. So the committee has recommended, I would say, amendment to 81J. So those amendments are: one, that whatever data protection bill or the recommendations are, it will have no bearing on 81J per se. Second, that in case anything which is there, or I would say that any information or disclosure should be ideally construed or assumed to be in public interest. So any disclosure should be taken to be in public interest, which is in contradiction, or I would say huge deviation from 81J. The third thing is that only in those cases where personal harm is greater or the personal harm to an individual outweighs the public interest, only in those cases that information can be withheld. Otherwise, all that private information have to be shared with the individual at large. So I would say in this particular case, right to transparency or right to access to information has been given at or kept at par with right to privacy. But we have to look into, because right to privacy so far was constituted to be a constitutional or a fundamental right. But in 2017, a categorical 9-judge constitutional bench judgment of the Supreme Court in case Puttaswamy has categorically developed it to be a very important basic fundamental right. Now, when right to privacy is a fundamental right, giving, I would say, statutory or more importance is, as per the committee's report, to right to information, I think will have to be looked into, because they have said that right to information have to be balanced and it has to be given more weightage, as per my understanding, than right to privacy.
Indeed. Anjali Bharadwaj, you have said, about the bill to several newspapers that it will have a very retrograde effect. Why is that so? And do you also believe that 81J has and can be misused?
So let me begin by saying that we believe that both the right to information and the right to privacy are very cherished fundamental rights. And we certainly believe that any intrusion into the privacy of individuals which is unwarranted must not happen. Surveillance, any kind of unnecessary intrusion is most avoidable and must not be allowed. But what we also believe is that in the context of a country like India, where information is key to holding governments accountable, we need to be very careful while balancing these two rights. Now, what we are finding is that the government has, on the one hand, for example, in the Supreme Court, claimed that people don't have a fundamental right to privacy when it comes to collecting people's data. But when it comes to sharing data of individuals, of public functionaries, very quickly they hide behind 81J, behind the privacy clause, and refuse to give information under the Right to Information Act. So like it was stated, the Right to Information Act already has a provision to protect people's privacy from unwarranted invasion, section 81J, and we believe that that actually is the paradigm within which the balancing act needed to be done. Unfortunately, what has happened again is that while saying that the section 81J will now be changed fundamentally, the Aadhaar infrastructure has been protected again, the architecture has been protected, because there is a clause which says this is only hold henceforth after the law is applied. Retrospectively it will not hold. So that means all the architecture, all the information that was collected from citizens linked to different places under Aadhaar will stay. But from now on, our worry is that section 81J, which was already abused and people were not given information on the pretext of privacy, will further be abused, and that is a real concern. And I will tell you one of the reasons why. For example, if one looks at the formulation that has been suggested by this bill, it says that personal data which is likely to cause harm. Now, likely to cause harm is a very low threshold. Many things are likely to cause harm. We have always insisted that there should be either imminent harm that is going to be caused by sharing of data or information. Just likely to cause harm is not good enough. Secondly, how is harm defined in the Data Protection Bill? Harm is defined as reputational harm or something that leads to blackmail. Now, in any case, a lot of the times, a false accusation is made that RTI users are blackmailing. Now, what can anybody blackmail using information unless something is actually going wrong? So when things are going wrong, there is corruption, there is abuse of power. People must be given information in any case. So the fear now is that with this kind of formulation that is being suggested, what is likely to happen is that in every case there could be denial of information, that it might cause likely harm, unless the burden of proof is on the individual asking for information to say that public interest is greater than the harm that could likely be caused.
All right.
So there is an issue where we feel that like this, personal data is defined very, very widely. Even my name is personal data, my date of birth is personal data, opinions are personal data. Now, given all of this, if the government is now going to be empowered to say no to people asking for information, it could be very regressive.
Right. Okay, so I'm going to come back to this likely harm that you've been talking about and who's going to decide on whether something is harmful or not in just a bit. But before that, let me go across to Mr. Azad. Mr. Azad, what kind of information do you believe should be and can be made public?
Let me say at the very outset that I appreciate the concerns of people like Mrs. Bhardwaj and also people who are talking ardently in favor of data protection. Now, protection of individual data is absolutely sacrosanct, there is no doubt about it. But on behalf of the RTI regime which we seek to protect with the Commission, let me say that there is already a robust regime in the RTI to protect private data. And 81J says that information will not be given out unless public interest outweighs. Now, public interest is paramount. This is a term which has been most used but least defined. And the courts have also said that it is not rigid, it is elastic. Now, Mrs. Bhardwaj's concerns are right when she says that in some cases, it is always used as a kind of a tool to deny such information. But I must say that there's a commission there, when it adjudicates the second appeal, it sees both the interests and only then it gives its judgment. So as of now, the regime is so robust that no changes are actually required. Let me also say that the Australian Senate Committee on Constitutional Legal Affairs, when it was defining and referring to the term public interest, it stated it implied that aggregating as many interests as opposed to the individual concern. So if the data has to be given out in public interest, say it's about a deep-rooted malady in the system, it's about exposing corruption, then of course the information needs to be given out. So this is a matter of a wider debate which needs to be at a national level and to be contested from both the sides.
All right, taking the discussion forward now, Piyush, will the RTI Act have to be amended if we have to get the data protection bill or if we have to take it forward?
Need not be, but there are suggestions for the amendment to the RTI Act. So, see, I think it has to be other way around. Ideally, it has to be other way around. So, data protection bill, I would say, hinges upon right to privacy. That's what data protection bill is all about. So, protecting data of the citizens of the country. So, it goes back to right to privacy. Now, interestingly, where does the right to privacy comes from? Now, it is a fundamental right after the recent judgment of the Supreme Court, 9-bench judgment of the Supreme Court. Now, when I was going through the report, K.S. Puttaswamy judgment, right to privacy of 9 bench is quoted 33 times in the committee's report. But ironically, in the RTI 3 pages of 102 to 104, it is not even quoted once. So I would say, my problem in this particular suggestions is something else. I'm not saying that RTI activists are not going to get enough information. Like Ms. Bhardwaj's concern is that they're not going to get enough information or it will be refused. I would say it would go down further. It is, in fact, the clause says any disclosure is going to presume that it involves public interest. So rather than going on likelihood of causing harm, it says it should be assumed. So right now it says that right to privacy is important, but what is more important is right to information. So I see the ramification not to the RTI Act alone, I see the ramification to the Aadhaar Act as well.
Right.
Because though the changes or amendments have been proposed to the Aadhaar Act right now, but the judgment is pending before the Supreme Court. So that it can be another, I would say, wheel for the government to play around that right to privacy is important, but not so important.
So is everything going to change, do you believe, Piyush, once the Supreme Court gives its verdict on the right to, on the Aadhaar Act, right to privacy, the bigger picture really?
See, that's what my bigger concern is. Supreme Court delivered this 9-bench judgment of K.S. Puttaswamy in 2017, last year.
Yeah.
And they said the right to privacy is a fundamental right. Now, where right to information is a statutory right, let us all recognize the fact it is a statutory right. Though courts have been saying that 19(1)(a) and right to life will be a part of fundamental right, but ideally it is a statutory right. It has to be below fundamental rights. It's a very famous quote that right to information can be about gossip, but privacy is a more fundamental to every human's existence. Now, once Supreme Court has protected it and as a part of fundamental right, here a committee's report is not quoting that judgment, though it has quoted it 33 times throughout. In these 3 pages, they are not quoting that judgment, they are relying on different judgments and saying transparency is more important. And what do they go on to say again? That for the transparency, you can bring in these amendments and people can have access, any private person can have access to another private person's information. Now, this is dangerous because now under the Aadhaar Act, or I would say irrespective which way the Aadhaar Act judgment goes, the government has information. Now, the proviso to this particular clause 8(1)(j) says any information being with the parliament or state legislature. Now, when the government has this information on the Aadhaar Act, irrespective which way the judgment goes, this can be very conveniently used by the government, be it state government, central government, for any times to come, that even though right to privacy was important, but see, we are giving you transparency. This is what we are giving to you. So yes, Aadhaar Act is important and privacy is important, but see, this is what we are giving to you. We are giving to you larger public interest. This cannot be done.
Right. Anjali Bhardwaj, right to privacy versus right to information. What are the pros and cons really, and how do we deal with this issue?
Well, I wouldn't say it's right to information versus right to privacy, because like I said, both are very important fundamental rights, and I would disagree that there have been judgments by the Supreme Court which have declared the right to information also to be a fundamental right, not a constitution bench, but certainly there have been judgments of the Supreme Court declaring the right to information.
But clearly, right to privacy is held in higher stature.
Right to privacy and right to information are both extremely important for people, for citizenry in our country today. And time and again, we have seen how important both these rights and the need to balance and complement them is. And therefore, I would not use the term versus. I would say, how does it need to be balanced? How does it need to be made complementary?
And more often than not, we are going to see both of them intertwine and cross paths at some point in time. So where do we draw the line?
Naturally. So now I think that like we discussed earlier as well, Mr. Azad also mentioned that the right to information law, when it was drafted, it already had a robust provision within it in terms of 81J. The 81J of the RTI Act says that any information which has nothing to do with public interest or public activity needn't be disclosed unless there is larger public interest. And again it says that any information which causes unwarranted invasion of an individual's privacy, personal information, that needn't be disclosed, again unless there is public interest that can be proved. Now the problem typically has been that how do you define personal information, how do you define unwarranted invasion of privacy are things which the RTI Act was silent about. What needed to be done was a greater discussion around some of this for clarity to emerge. Unfortunately, what we've seen is that by completely replacing that clause and putting in something which comes in at a much lower bar, if I may say so, what has happened is that this will actually push back the transparency regime. Why do we need information? A lot of times, why is it that people are seeking personal information under the right to information law? I will give you an example. For example, there are students who are supposed to get scholarships because they belong to the economically weaker strata. There are people who are supposed to get rations or pensions because they belong to a certain income strata. Now, this kind of information is actually information which can describe the characteristics of an individual and therefore will fall under the category of personal data. What is happening in our country, because corruption goes down to the lowest levels, people are unable to get their basic rights and entitlements like rations, pensions, scholarships, because there is so much corruption unless there is transparency. Which is why there has been a demand that the lists of people who are supposed to get rations, who are supposed to get scholarships, who are supposed to get pensions should be displayed so that there can be accountability, there can be a pressure and people can get their rights. And that is what we've seen. The only way to fight corruption and to ensure accountability in the system is through greater transparency. Now, what could technically happen is that in every case, people could be now asked to prove public interest, and it could actually be something that is left to the discretion of a public information officer somewhere who's also operating within this right as well. So now the issue here becomes that where do we feel the line should be drawn, because it cannot be drawn at a point where all the benefits that have come out of a regime like the right to information for people, which is why they demanded it, are rolled back.
Right.
So what we are saying is that while we protect privacy, we must put in place a regime where we make sure that public accountability is not evaded, where the government doesn't get the opportunity to say, we will not give you this information because it is personal data and you are unable to prove public interest. And like Mr. Azad said, proving public interest has been a huge hurdle. People are not being given educational degrees related information about their elected representatives because they are told this is private information, although it's put up somewhere. People are not being given information about whether they are beneficiaries and who all are the beneficiaries under various schemes. They are not being given information about assets and liabilities of public servants.
Points
so this
taken.
is information which should be in the public domain.
Piyush, you had something to add.
See, ideologically, I absolutely agree with Ms. Bhardwaj. When it comes to the RTI Act, it's a very important act, transparency is required, such provisions are happening. But the question here is are we missing on to the bigger picture? By this particular committee's recommendation, are we missing on to the bigger picture which can miss us notice right now? The government here is trying to say something more. They are trying to say that under the RTI Act, we are toning down section 81J. We are giving you more access to information. If you look into the amendments, I have contradiction in interpretation of it. Government says we are giving you more information. But who is taking that information? That is the question I am raising. It is citizens qua citizens. Now, under the fundamental rights, it is under Article 12 of the Constitution, state is defined. Only state can take away your fundamental rights, right to privacy or anything. And only state can commit any crime against you. That's why fundamental rights are protected. So if I am peeping into somebody's house, I'm not committing a right to privacy infringement. I am committing a crime. But if a state is doing so, or state is doing phone tapping by legal measures, that's violation of fundamental rights. So the more important thing is, now under this committee's recommendation, that a private individual or any citizen under the RTI Act can have access to confidential or personal data of citizens, personal information. That is more alarming. So they are having citizens, I would say the rights of citizens at par of looking into the as per the RTI into a constitutional right of citizens. Now this interpretation will lead to another conflict when I say with respect to any law now. Why
right.
so? Aadhaar law for that existence. Supreme Court tomorrow says that for Aadhaar card is not mandatory. Now data, the government has a data. Now any private person can move an RTA application. 81J now is toned down as per these recommendations, and he can seek personal data as per this toned down definition, because now disclosure has been assumed to be in public interest. He
right.
can take that data. That's not done, I would say.
Okay. Mr. Azad, I'm going to go back to a point that I'm coming to you. I'm going to go back to a point that Anjali Bharadwaj was making. She was talking about likely harm, and I was saying who's going to decide on that likely harm. At some point in time, someone will have to decide on what can be made public and what can't be made public. And, that will certainly have to be taken into consideration.
You see, I want to refer to some earlier points of the discussion too before this.
Please do.
There is a lot of confusion in understanding the information, right to information regime. It is not true that under the present scheme, every data about the individual is being given out to some other individual. Remember that the Central Information Commission deals with the central government only. The private enterprise are out of the RTI regime. Now, as I said earlier, RTI regime is a very robust regime in which the information which is sought is first seen by the CPIs, is then adjudicated in the first appeal, and then finally in the second appeal you really have to prove whether the public interest outweighs the personal interest. And that is why it is not true to say that every information which is asked for is given. Now the debate I was referring to is the same debate, that is the constitutional right over the statutory right, or however you put it. But balancing the interest of right to privacy and the public interest is something which has to be clarified, which has to be defined. Now, as Mrs. Bhardwaj said, the information asked for in many cases is like whatever the expenditure which has been done, say in terms of ration shops, in terms of any public delivery system, the information which you asked for really does not impinge on private interest and needs to be given. In fact, it is the basis of the RTI regime when in the Rajasthan villages, people like Aruna Roy was asking, like, Hamara paisa, hamara hisab. But certainly there are certain private interests which definitely will be impinged. Now in RTI questioning, many of the questions which relate to, they ask about bank details, they ask about pay details and the cuttings and things like that, which are of course denied unless a real public interest part is exposed. So my final comment would be that in balancing these interests, I would certainly say that the present RTI regime should not be touched. And that's my personal view, because it takes care of both. It
right.
takes care of data privacy, it takes care of individual protection of his right, and it also takes care of the public interest, which of course is being adjudicated by the Commission.
All right, time now to get closing comments from all my guests, on what's likely to happen and what's the way forward, really. Starting first with Piyush.
I would say that RTI, the data protection rules ought to have enforced under the RTI that how public information or private information when it comes to data protection ought not to be disclosed to people or state authorities for that matter in such cases. So that was one of the guidelines, because data protection, all the amendments are to protect private information. Similarly, in this RTI, or I would say Data Protection Committee's report ought to have been that how such private information not to be disclosed rather than how it can be disclosed. So that would have been, I would say, an ideal scenario, because for most of the acts, for 50 odd legislations for which the committee is recommending the, I would say, amendments, it is for the protection of the right to privacy. Similarly, it should have been, ought to have been done for the Right to Information Act, not other way around.
All right, Anjali.
Well, what I think is that starting from the composition of the Srikrishna Committee, which somehow had a preponderance throughout of people who had a pro-Aadhaar stance, and something that we did point out to the committee's chairperson, to the transparency with which the committee itself functioned, because there were many RTI applications that were filed asking for minutes of the meetings of the Srikrishna Committee, what were the submissions made to it, and all of those were denied. Most of them, those things were denied. I think what we really required the committee to do was to look at a larger picture, come up with a balancing of these two very important rights, and I think the outcome of it hasn't been quite what people would have liked. We have a situation today where the draft bill protects the Aadhaar architecture. What needed to have been said, if the committee is really interested in protecting people's privacy and their data, the first thing that needed to be said was to dismantle the Aadhaar regime, because they've collected a lot of information, linked it to people. We are talking about consent. Where is consent? People were made to sign off because everything was made mandatory. If you don't have Aadhaar, you will not get your pensions. If you don't have Aadhaar, you will not get a ration card.
Right.
Where has been the question of consent then? So what the committee needed to do was to really, if they were serious about data protection, to actually dismantle the whole Aadhaar infrastructure. What we have seen, however, is that there has been, in a way, I believe, an attack on the right to information regime by dismantling Section 8(1)(j), which was robust, and trying to bring in these proposed amendments, which now where anybody can say that there is going to be likely harm to the individual, and therefore information will not be provided, and the onus of proving that that harm is less than public interest lies on the individual who's seeking information, who in most cases, we know who's asking for information in our country. They're the poorest and the most marginalized most of the times who are asking for information. How are they expected to now start proving public interest in each case? And there is a great deal of compelling evidence to show how without this kind of personal information as well, many times, there is no chance of accountability and fighting corruption.
All right, divergent views there coming out of our panelists in the studio. Let's hear what Mr. Azad has to say in his closing comment.
I think this debate has veered around more on state accessing individual information in the name of security. I will not comment on that part, but what I have to say in the end is very simple, that today the RTI regime is absolutely sacrosanct, it is doing well, it balances the interest of both individual data protection as well as public interest, and I am of the view that individual information needs to be given when public interest outweighs the individual harm.
All right, on that note then, we'll call it a wrap on this edition of The Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. That's it from me on this edition of The Big Picture. See you again next time.